morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for our appeal entitled Steve Schoenberg versus RM Auctions and others. Our cause number 1CA-CV130419. We have set for 20 minutes aside. We've reviewed the briefs and the facts and the issues, and we've conferenced the case. We're prepared for your arguments. If counsel for appellant wishes to reserve some time for rebuttal, it's up to you. And if you'll let us know, we'll try to honor that. And but you have to watch your clock and assert that. And if you would each state your name for the recording when you begin your argument, in case somebody listens or watches this in the future, that'll help them know who's arguing. Having said that, Mr. Smith, is it?
Yes, Your Honor.
Please proceed.
Your Honor, I'm Donald Smith. I represent the appellant, Mr. Schoenberg, in this matter, and I would like to reserve 4 minutes at the end of this for rebuttal at the end.
Very well.
This case is really kind of simple. If you break it down, it comes down to the issue of the Castle versus Barrett-Jackson decision. In Castle versus Barrett-Jackson, this court basically said we don't have to reach the issue of whether or not the entity, the auction company, made any allegations, made any representations. Matter of fact, the court noted that in the motion to dismiss in that case, there was no allegations that there was any misrepresentations. And they said
By the auction company.
By the auction company, Your Honor. And then said, since they signed a waiver saying there wasn't any, we don't have to reach that issue. It's actually in a footnote, I think footnote 4 of the decision. In this case, we're not asking you to hold R&M Auction, the appellees, liable for any references, any representations or misrepresentations for the actions of the other party. We're asking you to hold them for what was not addressed, and that's their own misrepresentations. They made multiple misrepresentations prior to the auctions. They've admitted they made misrepresentations. They haven't disputed them. They haven't disputed them. Well, actually, Your Honor, Mr. Rose, in an affidavit, in an email turned over to the trial court below during the oral argument, says we have to believe the representations weren't true. If you look at that email, it's part of the record below. And he is an employee of theirs. And then they made, even after the bidder agreement is signed before somebody can get in, that the agreement is they made misrepresentations after that. So this is a case where they made misrepresentations concerning these cars. And this isn't an issue of puffing. It isn't saying this is the best Jaguar. That's not what this lawsuit is about. This lawsuit is about, this is a matching number car. This lawsuit is about this car is fully restored. Certain parts of the car is fully restored. Those are statements of fact. This is about statements that are made from the auction company saying, we're uniquely qualified to provide you information about a value of a vehicle.
Why wouldn't those statements by RM people be covered under the agreement in the same way as in the Castle versus Barrett-Jackson, by your client essentially agreeing that all such statements are from the owner, not from the RM people?
It's 2 reasons. Actually, 3 reasons.
Okay.
The first reason, R&M Auction made statements that are undisputed that they will assess and do the work. In the catalog itself, it says, we have made an effort to assess the statements in this agreement. That's from them. That's not an offer from a statement from the other defendant, Mr. Workham or his company. Mr. Gould, at his deposition, says, we do nothing. You're telling us that you do this, and then you admit during your deposition that we do nothing. That's their statement. They don't have to take that burden on. They can do what Barrett-Jackson did and said, nothing. But they take on in their catalog that they will do assessments, that they did their best. They did their best, but they did nothing. So they've done, that's different. Secondly, I think the statement in there from the company is more applicable to Powers, the selling the RV, Powers versus Guarantee RV, in which the court said this type of boilerplate statements should not be done to turn a nullity into our law. And it was talking about the Consumer Fraud Act, but I submit to you, common law fraud, if you, one of the most amazing things about the bidder agreement, the size of that you see in the paperwork, that's the actual size. I'll be honest, I can't read it. To read it, to get ready for this, I had to get the magnifying glass out. That's the actual size of the bidder agreement. So my point is that that it's more applicable, the Powers one, where it says if you allow this, you've made a nullity of the law. And the final nullity of the law is dealing with misrepresentations and fraud. Because basically what you're now telling these companies is, what you're telling these auction companies is, please lie, please misrepresent. As long as you have this little tiny print.
Maybe it's not please, but it's feel free.
Feel free to. That's a good point, Your Honor. We're truly the Wild West. We'll have the shootout at noon on Saturday. And that's what it will be. And remember, these companies, I will get to the third point, but these are a highly competitive time. There's 5 of these auctions basically at the same time. They're trying to pull in people from out of state. They all come in from out of state. They're not local firm. That's not true. Steel is a local firm. The others all come in from out of state, in the case of RM auction, from Florida and Canada. And they come in and they run their auction. They got to pull people in. So they make these promises about what they're going to do. So they have a reason to want to do this, and they get a benefit from it when they do it. The third reason is there simply is no agreement here. If there's ever been a contract of adhesion, this is a contract of adhesion. You hand it on the back of a bidder agreement in print that's almost impossible to read. There's no negotiations. There's no, is this acceptable, or do you want to negotiate the term? It's clearly take it or leave it.
Well, isn't that part and parcel of an auction run by somebody other than the seller? I mean, how could eBay? eBay. We don't hold eBay responsible for statements made in its descriptions of merchandise, and I think that's what underlay the Castle case.
But one more step, Your Honor, and that's the difference, is if when you go on eBay, and it's been a while since I've been on eBay, but the last time I remember, eBay says, here's the product, bid on it if you want to, and that's it.
Right.
And eBay did not say to you, we are uniquely qualified to inspect that device. We have, say you're buying an iPad.
So it's that statement, we are uniquely qualified and we've done our best to verify.
And we've done our best to verify. And by the way, we'll tell you the value. Please, remember, part of the quote, and there's a comment that's saying that the pages came off of 2013. The catalog gives you, in the catalog, I think on page 4, says, here's our web page. Please go look at it.
But eBay does do things like say, this is a preferred seller, this is a featured item, check this one out. They push emails to their
Correct.
customers saying, you might want to look at this. Isn't that somewhat akin to what you're complaining about here?
Just a slight bit different, Judge. eBay puts it up and says, here's the iPad. I work in hard facts, and I need that. Here's an iPad. It is this type. Here's what it's open, and they tell you we have an iPad. And if they tell you it's a preferred seller, they've done something to determine that's a preferred seller. For example, tying that to this case, Mr. Schoenberg testified that Mr. Gould told him this is the 7th car that he had sold for this gentleman. That it is, you could trust this gentleman. I know him. When I asked Mr. Gould in his deposition, had you ever sold, I don't know who this guy is. I have no idea. What eBay can't do to you is say, we have inspected this iPad, and it is perfect, and it's ready to go, and they did nothing. That's the difference. And the other thing is, this car is, when they post these cars and they put them up for show, you can't really inspect them. They're displayed in such a way that you cannot get up and look at them. I know that's similar in eBay.
But also, somebody who's spending 6 figures on an antique car has to understand at some level that inspections to the detail he's looking for are inherently destructive. You can't expect that an auction company is going to tear down the engine or remove parts that might be necessary to fully inspect, right?
To fully inspect, but you can check the VIN numbers. In this car, the VIN number was, as your honors know, there's multiple numbers on a car. And matching that.
Thanks for telling us that. I don't know.
Sorry, Judge. Okay, cars when they're sold have a VIN number, vehicle identity, the one you can see in your window, and then there's other numbers assigned to the car. Those numbers travel with the car throughout their lives. And when you talk about matching numbers, they match the numbers that were originally sold with the car yard. That makes a car much more valuable. In this case, for example, one of the numbers, I'll get back to you, Judge Swan. One of the numbers is at the back of the car and is under the license plate that can be easily inspected. Now, while Mr. Schoenberg cannot climb over the rope, take his screwdriver and start taking off the license plate off the car, the seller can, the auctioneer can. And in this case, that number was removed. That simple of inspection by R&M Auction would have disclosed that this is not a matching number of car. It would have been literally that easy for them. And now the other, and we're not saying they have to break down, but when you're selling that, by the way, that would have affected their evaluation. And I think you may try to hear that there's no evaluation by them.
Yeah, because I'm looking back at the briefs, and you one of the alleged false statements is that we strongly encourage those interested to contact us before the sale to obtain an objective care and honest condition report.
Correct.
Was that, did your client ask for that report and receive it?
He did not ask for that report, but if you look on the catalog, the estimated value of the car is printed on the page of the Jaguar at the very bottom, $75,000 to $95,000. That's the evaluation that R&M Auction puts on the car. So that estimate is there, and then the description is on the side, which R&M Auction puts in there. R&M Auction's position, the appellee's position, will be, oh, we get that from the seller. The document that says that it comes from the consignment document. The consignment document has a place where the seller is supposed to put in that information. It's not in there. None of this information is in there. There's nowhere that I've been able to find in this case. I went back and looked again before coming down here before this court, where the seller says, here's my position. Here's what I want you to print. That comes from R&M Auction. It's their catalog, and it's there. And they say that they did the inspection, but Mr. Gould, they say they check out that and they try their best to confirm it, but Mr. Gould says they do nothing. And that's the difference in Castle, Barrett-Jackson's auction, and in this auction. And there is a little difference in the two. They're basically the same, but there is slight difference in them.
I think I hear you saying that if the auction company simply receives information from the seller and publishes it, orally, written form, whatever, then that's the Castle versus Barrett-Jackson case.
And make nothing on their own.
But
that's Castle.
If they undertake anything on their own, or even if they say they undertake and don't, then that may be actionable and not blocked by the contractual language.
That would be our position, yes, Your Honor. That's what this boils down to. There's no obligation of them to take on that burden.
What other than the statement I read, which is that upon request, RM would provide an objective care and honest condition report. What other than that statement
Mr. Mott,
did you offer evidence that RM made to, along the lines that Judge Gamble was just outlining, we stand behind what the catalog states is the value?
read Mr. Myers' letter in the front of the catalog.
Okay.
It says that it makes that very same statement that we provide to do this, that we take the effort to do this. Turn to page 4 of the catalog, where they try to do a disclaimer. They said that disclaimer at the very bottom says that they do it, that they'll do it. Page 12 says we're offering you quality advice. So these are all in the catalog. I don't want to. I'm trying not to get into a dispute over what the computer says. These are in the catalog for this case.
Let me just ask you a procedural question. Was the catalog or any of the exhibits that you submitted authenticated properly by sworn
Mr. Gould?
testimony? No, it's okay.
I'm sorry, Judge.
Was it authenticated properly by sworn testimony, any of the exhibits?
Mr. Gould said it was the catalog. It was produced by the appellate as the catalog. It came from them.
Okay, but any of your exhibits as to any of the other oral representations?
Only from Mr. Schomburg's, what he was told. That's his testimony. And that's his disclosure. There was only one deposition done before there was a summary judgment.
Right, but his disclosure wasn't verified, so I guess I'm getting into...
I thought he did verify the judge.
I can check. I may be mistaken, but I don't believe his disclosure was verified.
I just turned 62, so I may be wrong.
I'm equally capable of getting wrong.
Young guy.
Judge, we're almost to the 4 minutes. Are there any more questions this board?
I guess not at this point. Thank you.
Thank you, Your Honor.
Good morning. May it please the court. Brian Pollack appearing on behalf of the appellees and also the cross appellants on an attorney's fee issue. And the appellees are RM Auctions. There are 3 RM Auction entities and then 2 of its officers that were all sued. I'm going to delve right into Castle because, as Mr. Smith mentioned, that is the primary issue on the appeal, obviously. There are some other issues. I didn't hear anything about them during Mr. Smith's opening remarks, but I will try to touch on them, including the breach of contract claim, for example. Before I get to Castle, though, as far as the record goes, I do think it's important to clarify a couple things. Number one, plaintiff's initial disclosure statement was not verified. If you look at the record, there is no verification. So in large part, in response to the motion for summary judgment, what Mr. Schoenberg did was point to his unverified disclosure statement. The only sworn testimony that's actually in the summary judgment record is a declaration that was provided by Mr. Myers that attached various documents, including the buyer's agreement that includes the language that's at issue.
But he didn't say the statements weren't made. I mean, I didn't read in your response to the, I didn't read in reply to your, in support of your summary judgment that any assertion that the statements were not made.
Right, and I'm not, I want to clarify which statements we might be talking about, because we sort of got 2 groups of statements. Mr. Smith in his opening remarks really focused on the statements regarding the Jaguar, which is, it's a matching number vehicle, and it was restored.
In the those
are in the catalog, and there's no denial by defendants that those are in the catalog. Beyond that, what Mr. Schoenberg has said in his unverified disclosure statement, we did not dispute it on the record down below, was that Mr. Gould, in Mr. Schoenberg's words in his disclosure statement, reiterated what was in the catalog. And that other RM Auction representatives reiterated what was in the catalog. Now,
the catalog is authentic, right? I mean, you're not disputing that the catalog's not properly before the court.
I'm not going to dispute that.
Okay. And does the catalog make these representations that we do our best, we try hard?
I'm not sure where it is that Mr. Smith is pointing to, because the only spot that I'm aware of that talks about us doing any sort of inspection, because if you look at the language that's at issue, that the language that's just like the language in Castle, really, that representations regarding the vehicles, buyer, by signing this and then therefore becoming entitled to bid at the auction, you're agreeing that representations regarding the vehicles come from the consigners, the sellers. We have no obligation to verify or authenticate. So beyond that, the only statements that I've seen Mr. Schoenberg and his counsel point to are the statements that Judge Johnson pointed to, which is, hey, we encourage you, go ahead and get a condition report on any vehicle or vehicles that you're interested in.
Well, I understand there's all that protective language, but is there also the language that we heard about that says, we do our best to inspect, we're uniquely qualified to tell you about the value of these vehicles, something that might give a buyer some sense of enhanced security that the auction company, I should go to this auction company because they've actually looked at these cars, unlike Barrett-Jackson, which has not. That seems to be the thrust of the argument, and I haven't seen anything to rebut that.
Well, that's because there's nothing in the record that RM Auctions made those statements.
So the catalog is devoid of the statements we heard about in opening argument?
Well, what the statements that have been pointed to in the catalog that have been cited before now are statements like, we're a global leader in the collector car industry. We offer the finest cars. That gets into our argument that that's sales puffery, and I haven't heard any dispute about that.
I'm waiting for do our best. Is there a statement in there to the effect that we do our best?
No,
Okay.
there's not. And I assume that what you're referring to is we do our best to verify the information that we're presenting.
Correct.
We do our best to inspect the vehicles, something along those lines.
Correct.
And there is
that not
no.
in the catalog?
That is not in the catalog. What is in the catalog, and what Judge Johnson pointed to, and I think this is important, is we encourage you, if you think that you're interested in a car or cars, come to us and we'll provide you a condition report if you request it. Now, in that case, we aren't presented with that case because Mr. Smith admits, and the record shows that there's no evidence that Mr. Schoenberg ever came to RM Auctions and said, hey, I'm interested in this vehicle. I want a condition report. There's nothing in the record about that. That didn't happen. So, now in that case...
If one requests a condition report, is that something that RM charges for?
I never got into that with the client because it was never an issue. I don't think that they do charge for it, but I'm not positive about that. But it just never came up because it wasn't requested. Now, I will admit that if they had done that and then RM Auctions came back and told Mr. Schoenberg, we've looked at the vehicle and we're telling you it's matching numbers, and we can tell you that, yeah, we've looked at the engine, we've looked at the transmission, we've looked at the suspension, and all of that stuff clearly has been restored. At that point, we'd probably have a problem relying on the Castle decision. But that's not what we've got. What we've got are the statements in the catalog about matching number and fully restored, up against Mr. Schoenberg's agreement and the bidder's agreement that statements made about the vehicles in the catalog brochures or in verbal statements by the auctioneers on the car cards, etc. Those are representations that come from the consignors, the sellers. They don't come from RM Auctions. So when you match those two up, this is really Castle. And I heard Mr. Smith say that Castle's distinguishable. I think he was trying to say that it's distinguishable because in that case the court said that, well, the plaintiff never alleged that Barrett-Jackson made any representations. And that's how the court dealt with the case. They didn't even have to get to the language in the bidder's agreement in that case. Well, that's not true. In paragraph 10 of the Castle opinion, the court does mention that in that case, Castle, the bidder on the vehicle, claimed that the event program, basically the catalog, as well as the car card on the vehicle or the window sticker, contained misrepresentations that the vehicle had been restored. He said that that was untrue. What the court said in paragraph 10 was that, well, Mr. Castle doesn't allege in his complaint that those were representations by Barrett-Jackson. He just doesn't say whose representations those were. So the court does say that, but then the court goes on and says, regardless, it's clear that they were not representations of Barrett-Jackson because Mr. Castle agreed in the bidder's agreement that representations regarding the cars made in the event program or on the car card are representations of the consignor, the seller, not of Barrett-Jackson, and that Barrett-Jackson has no obligation to verify them. And in fact, beyond that, the court in footnote 4 goes past that and said, because there had been a motion for leave to amend, I believe, in the trial court. And what the court said is, well, there was no basis for amending because of the documents that Mr. Castle signed. So From my reading of Castle, it's very clear that the court did get to this language and did hold that language like this bars misrepresentation claims based on statements regarding the vehicle.
Does it matter that this is, if this, seems to me it probably is, a contract of adhesion? Are there some circumstances where, yep, if you want to play, you got to play by the rules. We're going to set them.
Right. On the contracts of adhesion, the law is that standardized contracts are not unenforceable. I mean, there are situations where standardized contracts are unenforceable. So the term adhesion contract is getting thrown around. I'm going to disagree with it being an adhesion contract. Well, is it a standardized contract?
Well,
yes.
Sort of standardized, but isn't an adhesion contract one that you need to sign if you want to do the deal? We're not going to give you a choice. Before you can bid, you need to sign this.
I guess whether it's standardized or adhesion, yes. And in order to bid at this auction, Mr. Schoenberg needed to sign the agreement. So, he could have chosen not to bid.
So what? Yeah. So
right.
So what effect?
Yeah.
Assuming it's a contract of adhesion, what effect does that have?
Well, it doesn't have any effect here because what the case law says is that if it's a standardized contract that you have to sign in order to engage in the transaction, that doesn't make it enforceable. You need to go beyond that. You need to present evidence that the party that presented the standardized contract had reason to believe that the other party would not have agreed to a term. The Castle case deals with that issue too, because that was an argument that was raised by Mr. Castle. Hey, you can't hold me to this bidder's agreement because it's an unenforceable contract of adhesion. What the court there said is, okay, yes, it's a standardized contract. Okay, yes, the language is in fine print. But, Mr. Castle, you never came forward with evidence to show that Barrett-Jackson knew that you, or that Barrett-Jackson had reason to believe that you would not have agreed to this term. And the sort of evidence that the court pointed to, relying on Darner, was evidence like prior negotiations that made it clear that that wasn't the part of the meeting of the minds, or other evidence along those lines. And in Castle, the court rejected the adhesion argument because Mr. Castle had presented no such evidence. Similarly here, in both the trial court and now here in the Court of Appeals, Mr. Schoenberg has argued contract of adhesion didn't meet my reasonable expectations, but he offered no evidence in the trial court. He presented this court with no citations to the record showing where there's evidence that somehow this term RM Auctions knew that it was outside of his reasonable expectations. So just like Castle, there's no evidence here. And similarly, he's argued that it was an unenforceable release of future claims, and there's a lot of case law cited, usually in the personal injury context, that places limits on releases of future claims. That argument likewise was dealt with in Castle, because what the court in Castle said is, we're not talking about a release of claims here. We're just talking about the two parties agreeing that these representations are not coming from us. They're coming from the consignor. It's not a release of claims. It's simply everybody's on the same page that these representations are not coming from us. They're coming from here, Collectible Machine, the consignor.
What if the representation is about us, about RM?
Well, and that
isn't that different?
And I think it is different. So, and again, if RM had come forward and told Mr. Schoenberg had requested an objective care report and they'd given him that, I think that would be different. By the same token, representations about itself, yes, that would fall outside of, I believe, the Castle decision. And he does allege a lot of that, but as we point out, the statements that he all points to is all, for lack of a better term, flowery language that you're going to find in anybody's catalog. We're the global leader in. We only offer the finest cars. There's no dispute that that sort of language is puffery and it's not actionable misrepresentations. Those are really the only sorts of misrepresentations that Mr. Schoenberg has pointed to, language like that.
Is it your legal analysis that, just hypothetically, let's assume that an auction company decides on its own, and without information from the seller, but decides on its own to say that this car is A, B, and C, good things, and it's not. It didn't come from the seller, but there's one of these agreements. Would it still be covered?
If there was evidence in the record that it had actually come from the auction company, it had not come from, then perhaps
Even
there
though
may
the
be.
contract says all of our representations about this particular car or product are from the seller.
Well, and I think you need to even go beyond that, Judge Gemmel, and that is that there were actually two agreements here, and they're both in the record. There was the agreement with Mr. Schoenberg, the bidder. There was also a consignment agreement where Collectible Machine agreed that all of the representations regarding the vehicle were coming from Collectible Machine, and that RM Auctions was relying upon them for the accuracy of those representations.
But
so
that all works until RM Auctions or somebody similarly situated undertakes to make some statements to help them make a sale.
I'm having trouble grasping it because I think I'm understanding the hypothetical, and I would guess that there would be situations where that could lead to it falling outside of the Castle decision.
I wasn't exactly expecting you to agree with
Yeah.
that.
But there's nothing in the record here that shows that that's the case. And in fact, in Mr. Schoenberg's initial disclosure statement, which is what he relies upon heavily in responding to the motion for summary judgment in the trial court below, he explicitly acknowledges at page 3 of that initial disclosure statement that it was his understanding that the language in the catalog regarding it being a matching number vehicle and it being fully restored came from the consignor Collectible Machine. I think it's worth pointing out. So it's the second paragraph on page 3. The catalog indicated that this was an original matching number vehicle that had been fully restored and that all mechanical systems, including front and rear suspensions, had been completely rebuilt. It is Mr. Schoenberg's understanding that this information came from the Workham defendants. So there's nothing else in the record. There's no affidavit from Mr. Schoenberg. There's no deposition testimony from Mr. Schoenberg. There's nothing that would contradict that statement in his initial disclosure statement.
No wonder you didn't object to the fact it wasn't verified.
And I apologize. I can't remember whether we ever wrote to Mr. Schoenberg's counsel and asked for a verification. I really can't remember at this point, but I did recall that it was not verified. And in fact, there was no affidavit or declaration offered for Mr. Schoenberg in response to the motion for summary judgment. Mr. Smith is right. There had been one deposition taken. That was of Mr. Gould of RM Auctions. But again, that deposition transcript, you can search the record, but it's not going to be in there. It was never offered in response to the motion for summary judgment. So it had been taken, but it's not going to be in the record before this court. So if there's no more questions on this issue, if I can just spend a couple minutes on the breach of contract claim and then on the attorney's fees. So on the breach of contract claim, there had been basically two buckets of claims brought in the trial court. Misrepresentation claims, breach of contract claim. So Castle and our arguments about sales puffery really deal with the misrepresentation claims. On the breach of contract claim, what we've argued to this court is that Mr. Schoenberg has waived any appeal of the summary judgment on that claim because it doesn't get raised at all in the opening brief. In the reply brief, what Mr. Schoenberg says is, well, yes, it was, because Castle really, that was the argument, was that Castle disposed of all the claims. That's not what the argument was. Castle dealt with misrepresentation claims. The argument on the breach of contract claim was the contract that Mr. Schoenberg claims was breached was the bill of sale for the Jaguar. If you look at that bill of sale, which is in the record, I think it's record 85, it was one of the exhibits to our statement of facts in the motion for summary judgment. It lists the buyer as being Mr. Schoenberg, the seller as being Collectible Machine, and then RM Auctions signed that agreement as agent. And our argument in the trial court was there's law in Arizona that says that when an agent signs a contract on behalf of a disclosed principal, the agent can't be sued for breaching that contract. And that was our argument. And that was not argued at all in the opening brief, and therefore it was waived. On attorney's fees, there are cross appeals on attorney's fees. What happened in the trial court is... I've
got a question
Yeah.
on the fees. You say that the trial court plainly granted fees on the contract claim pursuant to 123101, but did not grant fees on the misrepresentation claim, disregarding your contention that the bidder's agreement required the court to grant fees based on any action taken respecting the auction. How do we know that's what the trial court did? I've read the minute entry, I've read the judgment. The trial court doesn't say the trucker just granted half your fees, roughly. How do we know?
Yeah, I think
Happen?
you have to make some inferences probably. So here's how the attorney's fee issue got to the trial court. So we went on summary judgment. We submit a Rule 54B judgment. We apply for our fees. In applying for our fees, we made alternative arguments. We argued, trial court, we're entitled to all of our reasonable attorney's fees, which was $73,000 and change, because in the bidder's agreement, there's a provision that says the prevailing party in any action arising out of an auction held in connection with this agreement, they're entitled to their fees. Alternatively, Judge, if you don't want to apply that, then 12-341.01 applies to the breach of contract claim. And what we argued to the court was that given that there were basically two buckets of claims, the breach of contract claim accounted for approximately half of our fees, and therefore that's what should be awarded, if alternatively. In the decision on the fee issue, what the trial court did was the trial court didn't discuss the fee provision in the bidder's agreement at all. The trial court discussed 12-341.01 and applied the Warner factors. And so we've read that as meaning the trial court, for one reason or another, rejected the attorney's fee provision or decided not to consider it and apply it.
Would it necessarily make a difference, though? The contract here is not a McDowell Mountain Ranch type contract that says all fees. It says reasonable fees. So if the court applied the language in the agreement, wouldn't it have also applied the Warner factors and gotten the same result?
It's possible that it could have. It just doesn't look like that's what occurred. I agree. It doesn't say all fees. It says all reasonable fees.
So how else would the court properly determine what fees are reasonable except by using the method it already used?
Well, I think it could use the method that it already used, but then it could include all of the fees in the pot instead of splitting it down the middle and then only considering those. I think is, and there's been some argument on the appeal that the fees that were sought were unreasonable, and that spending 50 hours in the motion for summary judgment was an unreasonable amount of time. There's other than generalities, though, there's nothing specific on those issues. So with that, I see that my time is done. So if there's no further questions.
Thank you very much, Mr. Pollack. Mr. Smith.
Let me address real quickly a couple of issues and let everybody go to lunch. There's clearly understood that there's undisputed that they had a chance to dispute the facts of Mr. Schomburg's states about what he was told by representatives of this company, and they never disputed those facts. So for the purposes of a summary judgment, those are considered undisputed. So what does the brochure say? The brochure says, or catalog says, this is Mr. Meyer's letter. Should you have any questions on any of the cars presented with this catalog, please do not hesitate to contact one of our knowledgeable car specialists for further information. He did. He did talk to this car specialist. That's Mr. Meyer's letter. It's page 4 of the brochure. Page 7. Although every effort is made to ensure the accuracy of the information contained in this catalog, and then it goes on to say, we trust and we investigate. They say that, and this is on page 7, every effort is made. Mr. Gould says, and by the way, Mr. Gould's part of his deposition was read in the oral argument. I think it's page 16 or 17 at the oral argument, his deposition, and so it is part of the record. Mr. Gould says, we don't do that.
Well, what is a reasonable person supposed to take from every effort is made?
That you make some. That you not that. Remember what Mr. Gould says. That would be a factual dispute. Is this effort enough? Is this effort enough? The issue for Mr. Gould is we don't do that. We don't do anything. We tell you we do, right, but we don't.
Let's hear the full quote.
Let me go back. Get my glasses. Although every effort is made to ensure the accuracy of the information contained in this catalog, such information is provided by the seller and may not be verified by R&M Auction prior to time. Any additional information or correction known at the time of sale will be announced. Buyers are advised to rely on their own information. An R&M Auction accepts no responsibility for the condition of the vehicle. Different, Judge.
Well, I understand the difference you're getting at, but when it says, although every effort is made, we may not know whether this information is accurate at the time of the auction, what's a reasonable person supposed to take from that?
That you made some effort.
Well, and what I might take from that is that they made some effort to make sure that they got the year of the car right, that the information provided by the seller was accurately reproduced in the catalog. But how can we hold on this record that a reasonable person would understand that to mean that they've actually crawled under the car?
I don't think they have to crawl under the car. And we're not saying, the issue here is not when you're buying a 45-year-old car, that the issue here is not whether the brakes need to be replaced. It isn't whether you need to change the oil or an oil filter. The representation here is that this is a matching numbers car. You then say you do representations that you check and you do certain things, which can be done quickly, and then you display the car so no one can check that.
That is the kind of representation that's likely to come from the seller.
But you can check that one. That one you can check. That's a statement of fact. Not this is the best car. That's a statement of fact.
Did they have an obligation to check that?
Because you said you would. And you told him you would, and then you display the car in such a manner that no one else can check. So they have to rely on you.
Your argument in part is that you can't say one thing in your documents and then deliberately do something different.
Correct.
That's not right.
Because people have the right to rely on you. And if this kind of agreement, this boilerplate agreement, I'm done.
Well, we'll let you sum up.
Okay. The bottom line,
take a paragraph.
If this type of boilerplate agreement can do away with a negligence claim, an intentional misrepresentation claim, the law on fraud, then those laws don't exist in Arizona anymore. That's it.
All right. Thank you very much. Thank you both for your arguments, your briefs and your oral arguments today. They're helpful, and we will take the matter under advisement and issue our decision in due course, and we'll be recessed now.